Due Process, recipient of 6 Mid-Atlantic Emmy Awards.
Face an extraordinary threat to our national security and the physical safety of the American people of a character that, at least in my lifetime, we have never faced before.
He is the quintessential prosecutor. Mafia conspiracies, the Whitewater land deals, racial profiling in New Jersey. Michael Chertoff probed them all as an unrelenting government attorney. But now he heads the largest investigation in this country's history. He is America's top terrorism prosecutor, and he's here for a candid conversation on this special edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
The war on terrorism, will it work? And what's the cost? In the struggle to be safe, will we pay the price in the loss of some essential civil liberties? I'm Raymond Brown, and there is no issue more important to our lives today or our prospects for tomorrow. And no one more central to those questions than Michael Chertoff, former U.S. Attorney, now Assistant United States Attorney General, and the Justice Department's point man on the fight against terrorism here at home. He's our only guest in this special half hour, but first, here's Sandy King with some background on the measures and the man.
Raymond, if you were watching CNN one day last week, you'd have seen Michael Chertoff again and again. An indictment in the murder of journalist Daniel Pearl, another in the Enron case on the role of the Arthur Andersen firm. But it's the massive probe and prosecution of terrorism in this country, with all its new muscle, that most defines his role these days. And no moment could have summed that up better than one marathon session late last year, when Michael Chertoff found himself before the Senate Judiciary Committee and before the cameras.
The President and the Attorney General have directed the Justice Department to make prevention of future terrorist attacks our #1 and overriding priority.
And as the department's top terrorism prosecutor, it is Michael Chertoff's job to not just carry out Bush administration anti-terrorist policy, but defend it.
Are we being aggressive and hard-nosed? You bet. But let me emphasize that every step that we have taken satisfies the Constitution and federal law as it existed both before and after September 11th.
But members of the Senate Judiciary Committee were not so sure. And when they grilled him last November...
And I want to thank you, Mr. Chertoff, for being here and for serving your government as well as you have for many, many years.
For more than 4 often tension-filled hours, Chertoff was in his element, offering no apology, prepared for each challenge, ready for the fight.
So for those who question whether we are at war, my answer is Mr. bin Laden has declared war on us.
Of course, Chertoff's had plenty of practice in wars of law.
I mean, this is not the first corruption case we've successfully brought, and it won't be the last.
And wars of words.
There is no greater sin that a public official commits, but that he offers his name as a public official, his power as a public official, and his influence as a political figure for sale to the highest bidder.
And wars of nerves.
That was separate from DOJ. I don't recall...
When did you make the decision that was separate from DOJ?
I made no decision.
Who made the decision that it was separate?
Witness last year's state Senate hearings into whether Peter Venero, former state AG, now state Supreme Court justice, had ignored the evidence of state police racial profiling.
Yes or no? Was it made clear at the meeting that this issue of racial profiling was a big problem for prosecutors in New Jersey?
It was in the middle of those state hearings that Chertoff was tapped for the national role as head of the Justice Department's criminal division, a job that grew from big to huge in the wake of September 11th.
We face an extraordinary threat to our national security and the physical safety of the American people of a character that, at least in my lifetime, we have never faced before.
But it wasn't Chertoff's D.C. debut. That came 6 years earlier, when Chertoff, by then a GOP loyalist, was named special counsel to the U.S. Senate's Whitewater probe. So it was no surprise that the one vote against his latest confirmation came from Hillary Clinton.
You can't do this job if you're worrying about whether you're going to step on people's toes.
That was Chertoff's opening salvo back in 1990, when at 36, he became the U.S. Attorney for New Jersey.
Congratulations.
A job that took him from union corruption
Nicky Scarfo has continued to run and influence the affairs of the union from prison.
to medical fraud
We can't afford to have criminality infect our healthcare industry.
to political corruption
There is nobody in the state that's too powerful to escape the reach of the law.
and even hate crime.
When the motivation is perhaps the ugliest we confront in this society, which is race hatred and ethnic hatred.
It was the high-profile cases and a string of successes going back to Harvard Law School, where he was editor of the Law Review, and the New York U.S. Attorney's Office, where he specialized in organized crime, that earned him his stripes.
For so long as I am United States Attorney, the U.S. Attorney's Office will be guided by an unswerving commitment to equal justice under law in the service of the public.
That and a style marked by icy calm as a hard-as-nails, unflinching prosecutor
You might say that this is a story of rags to riches to jail.
that have brought Michael Chertoff to a principal role on the national stage.
And to that end, we are aggressively and systematically conducting an investigation that is national and international in scope. But I believe we are doing so within carefully established constitutional limits.
The Judiciary Committee had him for more than 4 hours. He is ours for just the rest of this half hour. And we've got a lot of ground to cover. Michael Chertoff, thanks for being here.
Nice to be here, Sandy.
Michael, there are a lot of controversial measures that have been associated with post 9/11 and your tenure in the Justice Department. Much of the testimony in the video Sandy put together revolved around military tribunals. But there also have been questions about justice regulations concerning eavesdropping on lawyer-client conversations, wiretap and search powers expanded for the Justice Department, as well as increased detention powers, especially with respect to immigrants. That's a lot of stuff. Where I'd like to start is with the new definition of terrorism, domestic terrorism, that's in the Patriot Act, because it has the potential, as many civil libertarians have pointed out, to be used with respect, say, to people like the Seattle demonstrators against World Trade, where you have an intent to intimidate the government, which is part of the criminal element in that statute, but which is also a treasured means of expression. And there's the possibility these statutes could be used against people none of us would think of as terrorists. Is that a subject of concern?
Well, actually, if you look at the Act, all of the elements of what constitutes various crimes of terrorism involve acts of violence. And there is no First Amendment right to commit acts of violence or to physically intimidate people. One thing that you have to concede if you look at everything that we've done since 9/11 is there's been no suggestion that we are going to punish people or investigate people for espousing viewpoints, even if they're unpopular. What we're focused on is action. People who solicit others to commit bombings or to kill innocent American civilians, people who become suicide bombers or plan suicide bombings, people who cause other kinds of acts of violence in pursuit of a political end.
And I think maybe that's exactly where the controversy is. No one would question your willingness to go after people who are going to do bombings. But this legislation, for example, would seem to encompass people who want to intimidate, meaning if I bring 5 million people to Washington to make the president change his policies and somebody starts throwing bottles through a window, while that may be a criminal act, it's not what we think of as terrorism. And so the idea is that maybe these powers are greater than the ones that were anticipated by people concerned about terrorism.
I think if you actually look at the law, you'll see that really the touchstone is acts of violence. And of course, as we know, acts of violence are never allowed by the law or by the Constitution.
Michael, you've obviously been following, as we have, the civil liberties concerns as they've been raised, and not just from one corner. It hasn't all been the ACLU. We've heard really all parts of the political spectrum saying there's some problem in the way the Patriot Act is written, in the executive and DOJ orders. Someone said to me about you, who claims to know you pretty well, Michael Chertoff's really far more liberal on civil liberties issues than you would expect. Whether or not that's true, is there no part of all of this that gives you pause as somebody who has embraced the Constitution for your entire adult life and makes you sit back and say, maybe this I'm not totally comfortable with?
You know, actually, Sandy, we went through this exercise when we sat around and talked about the Patriot Act and also other measures that we've put into effect since 9/11. Because I think everybody was concerned about not feeling in 5 or 10 years from now that we've done things that we believe are inimical to the Constitution or damage civil liberties or change the fundamental character of the way the country operates. And I think if you actually look at the measures that we're talking about, although there are legitimate differences of opinion, in the main they're pretty balanced. We haven't done a mass internment along the lines of what happened in World War II. We haven't suspended habeas corpus like Lincoln did during the Civil War. What we've tried to do is take, in many cases, quite tried and true constitutional methods and apply them to the new technology and the new challenge that we face after September 11th.
And the changes that you've brought and that you are now charged with enforcing, whether or not you are the man in charge, as Raymond pointed out, they will be there. There are none of those that you think open the door for abuse, for excess.
I think not. I think actually if you look, and sometimes you have to be specific, but if you look at the measures with respect to wiretapping, for example, many of these simply update existing law to apply to new technology, but it doesn't change the fundamental balance between civil liberties and the right of law enforcement. Other things like military commissions, of course, are unusual, but that's because we face an unusual situation. And there again, we have historical experience, we have a body of law that governs these kinds of tribunals. So I think all of this, as it plays out, is going to turn out to be sound and balanced.
Somebody who has expressed great admiration for you, Harvard Law professor Philip Heyman, who has called you a brilliant lawyer and a brilliant prosecutor, says, however, that the idea of the military tribunals is a terrible offense to our national tradition of justice and wholly unnecessary to our security. How do you answer him?
That can't be right, because in fact we have a history of using military commissions. We've used them in the Civil War. We used them during World War II when President Roosevelt authorized a military commission with respect to saboteurs. And let's talk practically about what we're dealing with. We've got hundreds of al-Qaeda and Taliban fighters in Guantanamo now. Do we really want to necessarily force the president to bring hundreds of potential terrorists into this country and try them in federal courts without giving him the option of determining that some of them ought to be tried for war crimes and military commissions? You know, a little known fact about military commissions is that after Nuremberg, we had military commissions throughout Germany to try Nazis and other war criminals. And those worked perfectly well. I don't think there was a hue and cry about violations of fundamental human rights. So again, I think when you look at the historical record and you look at the exigencies we face now as we're in the middle of a war, this is a sound alternative.
Michael, the tribunals that came after Nuremberg were patterned, though, on an international military tribunal that was a result of a treaty and that involved many nations. And that sort of leads me to the next point, which is perception. Although we disagree often on issues, I know that you care about constitutional values and the extent to which maybe the heart and soul of this republic is a special relationship. Do you think, for example, that when the rest of the world argues with us over the application of the Geneva Convention and perceives increased detention, especially of immigrants, that doesn't change the way America's relationship to the idea of justice is perceived around the world?
Well, first, Raymond, it's a good opportunity to correct a misimpression. The Nuremberg Tribunal, the original one that people think about, was in fact an international tribunal. But after that, all the countries involved in the war agreed that within each zone of occupation, each country would conduct its own military commissions. So there is sound historical precedent for what we're doing in this instance. Obviously, what the world thinks matters, and we do try to explain our position, and we do try to work with our allies. At the same time, we were attacked, And we have the responsibility not only to punish those who committed the attack, but more important, to prevent future attacks. It's going to be cold comfort if, God forbid, there's another World Trade Center type catastrophe, if we feel we haven't done everything we can do within the bounds of our law to prevent such an attack by incapacitating those terrorists and terrorist conspirators that would do us further harm.
Michael, one of the things that this administration is doing, it's not coming out of your office, but you're obviously going to be a part of it, is this new color-coded 5-step terrorism warning system. It's taken a lot of heat. It's been the subject of jokes and ridicule, as you know, and other people who just say it's silly and it's not going to work. Does this system, to you, make sense? And is there any chance that we would ever get back to green?
Well, I hope we get back to green. And you can debate about whether you ought to have 4 colors or 5 colors. And I know that this was put together with input from people from state and local government who obviously are the recipients of the warnings. What we're trying to do is strike a balance between giving people what they're entitled to know about threats without putting people in a state of constant alarm or getting into a cry wolf syndrome where people get so used to high-level warnings that they disregard them. And this is a perennial problem. We get all kinds of information. Some of it is specific. Much more often it's very general. Do we simply sit on the information and deny people the right to know that there is a general threat? Do we convey the threat, but recognize that it's not very helpful for people to hear that there's a threat somewhere in the world, that something's going to happen over the next month? So I think this has been an effort to balance these concerns in a way that we hope will be helpful to state and local government officials and to the public at large.
Let me come back, since we've used the word threat, to another area that some of the critics of the administration have perceived as a threat, and that's the Department of Justice regulations on eavesdropping on lawyer-client conversations. It is a limited class of people, but it's been expanded by the new regulation, or at least clarified so it's more expansive. And there certainly is concern that the Attorney General can make a judgment on his own that would permit this kind of interception that might chill the ability of people in detention to talk openly with their lawyers. I know you care about the Sixth Amendment. Does that give you any pause?
Well, again, I think we tried when this was put together. I think the department tried to, again, balance the need to make sure that terrorists sitting in jail are not conducting terrorist business through their lawyers, but also not wanting to interfere with people's legitimate rights to get legal counsel. We have, for example, a fellow in jail now named Ramzi Youssef, who was not only responsible for masterminding the World Trade Center bombing in '93, but also the Manila air plot, where he tried to have 11 airliners blown up simultaneously and was frustrated only because one of his Confederates was found out. This guy sitting in jail, if he were given the opportunity to communicate freely with the outside, there's no doubt he would try to encourage further acts. What we have tried to do, though, is to protect the constitutional right to have serious discussion about your legal situation by making sure that whatever is listened to with full notice to both parties is not conveyed to prosecutors unless a federal judge determines that there in fact is some illegal threat activity and then allows it to be disseminated.
Do you think that might chill the impact on his conversations? I mean, if I knew that every intimate conversation I was having for the next month was going to be intercepted, it might affect what I said, even though I would be aware of it.
Well, it shouldn't, because I think we do have safeguards in place to protect legitimate attorney-client conversations. What it might chill is the desire to conduct criminal business from the jail cell, and if it chills that, that's not a bad thing.
Michael, of course, there's also the chilling effect that some charge on speech, free speech in this country. I mean, we had Ari Fleischer in his now infamous comment, people have to watch what they say and watch what they do. Do you buy that there's been a chilling effect? And we obviously can't let you leave here without talking about the effect that all of this perhaps has had on profiling. Racial profiling, something that you, of course, were in the forefront against in this state, and that some people think that you are in the forefront promoting in your job in Washington.
Well, putting aside the occasional stray remark, maybe or inartfully worded remark, I don't think anybody has suggested that there's any desire to chill debate about policy matters and things of that sort. The issue of profiling, though, I do think is important, because one thing we've tried to be very clear about, we are not looking to conduct ethnic profiling or racial profiling or religious profiling. I think
Not intending it, Michael, but is that in fact the bottom line? if in fact, for all the reasons you told the Senate Judiciary Committee, the people whom you are most likely to look at are of Middle Eastern descent or Arab or Muslim on certain kinds of visas, doesn't that all add up to a kind of ethnic profile?
I think we've been careful to say we don't look at people of particular descent. What we do look at is this.
The countries of origin.
Well, for example, where has somebody been? We do know,
and
for
where
example,
do they come from? That is one of the things you look at.
Not where they're born, but where they've traveled, for example, recently. What kind of visas
Not
they
where
have.
they're born.
Not where they're born. Where they've traveled, where they've, what kind of visas they've had, what kind of educational institution are they attending? Are they going to flight school? Does it make sense for them to be going to flight school? And it is true that we have to be careful not to let that stray into general ethnic profiling, but I think everybody's been quite careful, from the president on down, to make it emphatic that we do not view people's ethnic background or religion as a predictor of being terrorists or being criminals. On the other hand, we would be foolish not to be mindful of the fact that there were training camps in Afghanistan. And if someone has spent 2 or 3 months in Afghanistan and then come to the United States, and if they're here on a student visa and they're taking flight training, those are things we at least have to look at. And I don't think that constitutes profiling.
Let me just ask you, we met a man on this show 2 weeks ago of Turkish descent, an American citizen from Patterson, who was accused by a co-worker of having said some negative things about the United States. He got a visit from the FBI at 10:30 at night for 2.5 hours and was terrorized.
Now, I didn't see that.
Where does that fit?
I didn't see that show, Sandy, but I think you point your finger at what is a difficult issue. Clearly, there are going to be instances where, let's say, somebody makes an accusation. I can think of some we had against somebody, maybe because it's a former girlfriend or a former wife. And they may say so-and-so is planning, has said they want to blow up a building. Now, we have to investigate that. We cannot afford to simply shrug it off. And it may be unpleasant to have the FBI visit you and ask you questions for 2 hours. At the same time, the important thing is when, at the end of the day, the charges are shown not to be founded or the accusation is not founded, we don't simply arrest someone or detain them. You know, we go our way and they go their way.
Of course, this was an American citizen, and the detentions are of another group.
There's sort of a spillover effect that I just wanted to press, and that is that you're one of the smartest lawyers, if not one of the smartest people in America, and well-trained. But when it spills down all the way to a patrolman who may not have your training and may not have focused on all the nuances, the effect still has the potential of saying, look, we're singling out people who look a certain way or have a certain religion, and that comes down on a street level to something that looks a lot like profiling.
And that's why we tried to be emphatic about the fact that we really don't want people to be engaged in ethnic or religious profiling. Specific characteristics based on past behavior, based on things that people are, signed up to do, that may be appropriate, but not based on religion or racial background or national origin. And I think we've tried to repeat that message, and I'm happy to do it here again. That's not what we wanted to do here.
Michael, let me ask you something, turning to a different page. You're in the news as much as anybody. You're out of New Jersey now. You've moved out of Westfield and relocated down to D.C. But do we expect that we will see you back here? And when I hear rumors that Michael Chertoff might at some point consider running for U.S. Senator or governor, is there something to this?
You don't hear any rumors like that. I do. When I took this job, obviously it's not a lifetime job, and nor should it be a lifetime job.
So as you look down the road past this job, does that look to you like a maybe?
Honestly, Sandy, I don't, it's almost impossible to look past this job because since 9/11, literally day by day, we are all engaged in an endeavor that the likes of which we've never conceived of, at least not in my lifetime.
Your answers are usually laser-like. That answer doesn't seem
you
laser-like.
You haven't ruled it out.
I think it's pretty laser. I have no intention or interest in doing anything other than the job I have now.
Are you ruling out the possibility of a future run?
I'm not going to get into this. I'm not going to go into imagining what the rest of my life is going to be like. What I am going to do is say that I have a privilege, a rare privilege, to be able to serve at a time of challenge, which I think is even a greater privilege than service in ordinary times. It's an exhausting job. It takes everything out of you. It's very difficult to imagine what you might do even 2 years from now, let alone 20 years from now. I do know that in terms of satisfaction and feeling the opportunity to make a contribution, I can't imagine anything that would be more satisfying than what I'm doing now. And I really can't, imagine or think about or speculate about what I might want to do at 10 years or 20 years, if I wanted to be a judge or if I want to be in private practice. Those are things which are very remote from the kinds of things we have to deal with on a day-to-day basis.
We've only got 15 seconds. Any chance the war on terrorism is over in less than 10 years, or are we looking at indefinite periods?
I think, unfortunately, terrorism is going to be with us through our lifetimes and the lifetimes of our children.
Thank you for joining us, Michael. That's it for this special edition of Due Process, but we'll be back next week. Till then, for Sandy King and all of us here at Due Process, I'm Raymond Brown. Thanks again, and especially thanks to you, for Mike Chertoff, for joining us.
That is hearings such as this and the things that have been written in the press, the concerns that people have expressed about what these military tribunals will in fact be and how they will occur has an effect on you, so that as you go forward and implement this, you will take into consideration, I am assuming and I believe, the full concerns of people in this country, whether they be from the left or the right, about our civil liberties and how precious they are to us.
Well, Senator, let me say, I'm sure everybody's concerns will be taken into account. And as Thomas Jefferson said in his inaugural, in this, we're neither of one party nor another. We're all Americans, and I think that's our spirit.
I thank you. I thank you, Mr. Chairman.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,